Good morning. Part at least of today's proceedings are going to be broadcast by live stream, voice only. Those with electronic devices may use them to report what they have heard in the hearing room, but only 10 minutes after the event that they're describing has elapsed. Those devices may not be used for recording. Yes.
Thank you, sir. HM1, can you see and hear me?
Yes, I can. Thank you.
Thank you. Could we pick up, please, on the questions I was asking at the end of yesterday, which were about a national day of action against the fur trade on the 16th of March of 1996. And can we have a look, please, at your witness statement, page 90, paragraph 225. Page 90, thank you. And in relation to the end of the day, the demonstration in St John's Wood outside the Hockley home address, and by reference to the report that I was showing you yesterday, you said this: upon reading the report, it rings a bell that Privacy was arrested, but my memory does not extend beyond the report. Toward the end of the day, as I remember it, the police were controlling entry to the tube station and minor scuffles broke out. That was when I was arrested. I did not see Greg Avery arrested, but I presume he was arrested at the same time because we were in the same police cell. Does that represent the extent of your recollection of the circumstances of your arrest?
Yes.
And if we go, you add a little bit of detail at paragraph 226, just to set that out. You say you were asked about a custody record and a briefing note which gives slightly different details about the circumstances of your arrest. And you say that the briefing note records your arrest while taking part in animal rights activity targeted against Michael Hockley. The custody record shows St John's Wood Station as your place of arrest. And you say, I was arrested outside St John's Wood Station, making my way back from Hockley's home address. Immediately before my arrest, I was trying to get into the tube station. Is that accurate?
Yes, it is.
So your recollection, is this right, that there were police in the vicinity of St John's Wood tube station?
Yes, quite a few.
And you were trying to get into the station to leave the area, is that right?
Yes.
And are you able to explain how a scuffle broke out in those circumstances?
Well, my memory is it was just one of those police were trying to control entry into the tube station, and somewhat eager to get into the tube station quicker than the police were allowing. And in one of those sorts of confrontations, people were arrested, or I was arrested.
But why would there be a confrontation between the police if they were trying to usher people away from the area and those people were trying to get into the tube station to leave the area?
Well, I think it sort of, there was a body of people that had come back from the nearby demonstration, and I think they were just trying to regulate the people going to the tube station. That's my recollection.
In terms of your personal activities or actions that led to your arrest, are you able to assist in any more detail with what precisely you were doing that caused you to be arrested?
Yeah, I think I just, it was a sort of minor contesting of why I'm in this queue and tempted to walk, if you like, past one of the officers saying, not yet, and got caught up in that argument.
All right, so an argument with a police officer led to your arrest?
Yeah, it was not ready to come in yet. I'm now going to try and go in, sort of thing. It was all over in a second. It was a bit of wasn't a particularly sensible thing for me to do, but that's what happened.
Forgive me, in terms of the grounds for your arrest, what did you understand them to be?
Minor breach of public order.
And as a result of your direct interaction with a police officer?
Yeah, sort of confronting sort of attempts to control still a sort of rather agitated group of people.
Could we have on the screen, please, a note, a management note, MPS 0246208. It's your B151, sir. And this HM1 is an SDS briefing note bearing Keith Edmondson's name, dated in the bottom left-hand corner, the 20th of March, and in fact at the top. And could we zoom in, please, on the circumstances of arrest section of the document? And so this records that at 5:30 p.m, while taking part in animal rights activity targeted against Michael Hockley, you, with other like-minded activists, were arrested for conduct likely to cause a breach of the peace. Does that ring a bell?
Yes.
And it records all arrests at about that time took place after the activists had spent some time outside Hockley's home address pouring a torrent of vitriolic abuse at the hated fur trader. Your arrest didn't in fact arise from the events immediately outside the Hockley home address, did it?
No, it was the tube station's quite close, so it was a spillover from that event.
Well, the tube station's about 10 or 15 minutes walk from the road where the Hockley address is, isn't it?
I can't remember, but it's within range of most people going back to the tube station.
The next paragraph records you being taken to the police station, detained and released without charge at 9 p.m. Again, does that ring bells with you?
Yes.
Were you interviewed, do you recall, or were you simply detained and then released?
Detained and released.
And you were arrested alongside other activists. Were you held with other activists? I think your statement suggests you were held with Greg Avery.
Yes, we ended up in the same cell for a bit.
And you informed the management, did you, of your arrest as soon as you could?
Yes.
If we look, please, at the next section of the document, under welfare. This note records that you did that, and it also records, I was able to establish that he had suffered no untoward physical injury, although the arresting officers had seen fit to remind him that his presence was unwelcome in their police area. By the time I spoke with him again, he was at home in the tender care of his wife. Again, similar to questions I asked you yesterday, was there an assumption that your wife, your spouse, would perform a welfare role for you in these sorts of circumstances?
Yeah, I think there was a natural expectation that that was sort of an enduring part of the relationship we had. Yes, wasn't specifically related to this.
And so, well, my question was really aimed at the expectation. Was it, because this is a document that was drafted in the name of or by Detective Chief Inspector Keith Edmondson, did you feel that there was an expectation that your wife was to offer you care and support in these sorts of circumstances?
Well, I don't know what his expectation was. I mean, that was just something that was naturally there. I didn't even give it any consideration. It was just that was a given.
To what extent did you feel able, or were you permitted, to share with your wife what had happened to you? Were you expected to keep it from her, or were you permitted to share with her that you'd been arrested in your undercover role?
No, absolutely could have shared. I mean, we shared most things. It wasn't in itself, in that sense, a big deal. The big deal for me personally was the injury.
All right, I'll come to that then. This document I've just read out says that it was established you had suffered no untoward physical injury, although arresting officers had seen fit to remind him that his presence was unwelcome in their police area. That's a euphemism, isn't it? You were assaulted by the officers in the van.
Yeah, so I've described what happened. I say that's not my wording. So what I've described what happened, and
Yeah,
as a result of, sorry, go on.
no, I'm sorry to interrupt you. I was going to ask if it would assist you to have your witness statement where you describe it to refresh your memory.
I think I'm okay with this one, but it was after being put in the van and taken to the police station. I remember being held in a way that I suffered what turned out to be, I didn't know at the time because I thought it would just get better after a bit of a sort of bit of a scuffle, but it turned out to be a fracture, a hairline fracture.
Yeah, of your rib, I think, one of your ribs.
Yes, yeah,
And what you describe in your witness statement was being placed head down on the floor of the van and the officer putting their knee between your shoulder blade and your spine. Is that right?
yes,
And this was following your arrest for a breach of the peace.
yes.
How did you feel being in that position, treated like that by a fellow police officer?
Well, I was more the concern at the time was how much of this and does it get any worse before I declare my hand.
All right, so you were contemplating saying to the officer, please stop, I'm a police officer.
Not really, but I remember thinking I would like this to be over very quickly.
If we turn to page 2 of the note, please. There is a further note from, or in the name at least, of Detective Chief Inspector Edmondson. Could we zoom in on that top half of the page? The whole, thank you. So you were spoken to on the 25th of March at the meeting about what is described as the continuing after effects of your encounter in the police van on the way to the police station with the TSG officers who arrested him. And what's recorded here is that it seemed you'd suffered severe muscle strain to your chest and back, may have cracked a rib, although not definitely diagnosed, but you'd taken yourself to hospital and had an x-ray and some tests. Is that right?
Yes.
And so it took a little while, did it, a number of days, for it to be confirmed that you had in fact suffered a hairline fracture to your rib?
Yes.
The second paragraph, starting that being said, the second half of that paragraph says this, I'll start again. The first part of the paragraph indicates that you asked the Detective Chief Inspector if he would make a Form 438 entry for you.
Well, I don't remember specifically asking him to do that. That would have been, I think, incumbent upon him to do so.
And can you assist us? A Form 438 entry, is that reporting that you'd been injured on duty?
Yes, from having read this, that's what it is. Yes, absolutely.
And this note records Edmondson doing that, to quote, couched in suitable terms, and a copy is on his file in the SDS office. If we have a look, please, at that form, MPS 0746162, B149, sir. This is what we understand to be the injuries on duty form. It bears Mr. Edmondson's name at the bottom. And if we could zoom in on the details at the top of the page, first of all, please. It records your arrest as being in Ludoon Road, NW8, which is in fact where the demonstration took place, isn't it, rather than the tube station?
Yes.
And it gives as the type of duty demonstration.
Yes.
And then if we can look, please, at the body of what was reported on this form, the handwritten, thank you. And so what was entered on this form is that you were involved operationally in monitoring a demonstration and picket. And during the course of this hostile event, you were caught up in the events and injured in the ribs and back by the general activities and actions of those taking part. That's not the truth, is it?
Well, I mean, it's not my language, but I'd imagine, well, it's sort of a generic description without being explicit of the type of work I was doing, presumably because this goes on a general welfare bit of one's personnel file.
But you weren't injured, were you, by the general activities and actions of those taking part in the demonstration? You were injured by the actions of a police officer.
Yes.
Why would it not be possible simply to report that you had been injured by a police officer?
I don't know. I never wrote this, and I never saw it after it had been written.
Did you feel that the injury to you was being taken seriously by your managers?
Yes.
Did you consider that they appreciated the circumstances of your injury, namely that you were already in a police van and you were subject to force from a police officer?
Yeah, we had a lot of conversations about it with my associates in the field and with colleagues, inverted commas, friends who were concerned about my injury. So from all angles, people were concerned and wanted to know what I was going to do about it with different perspectives.
At the time that the force was applied to you, were you offering any physical resistance to your arrest?
Well, not once in a van, I don't recall. I just recall it being a pretty crowded van and being put in that position pretty quickly.
So on the face of it, you had been assaulted by a fellow police officer, hadn't you?
It certainly felt as though I didn't quite deserve this sort of treatment, that's for sure.
Was any consideration given by you or your managers, to your knowledge, about reporting the officer so that, for example, disciplinary action could be taken against him?
So in all the conversations I had with everyone, I actually the general thrust was, I'm just going to get better, thanks. This is going to recover. On either side of the fence, I don't want to make an issue of it. It would just get horribly complicated. From the point of view of suing the police, from the other side of the fence, to the point of view of any sort of action, complaint against a fellow officer, which I wasn't minded to do.
Were you not concerned that there were fellow police officers out there willing to commit physical assaults on arrested activists, people arrested for something as minor as a breach of the peace?
Well, I'd put this down to just an isolated incident in the heat of the moment. I wasn't there to change the world in that respect. I could have walked away from that scuffle by just not insisting, but I sort of jumped the queue. So no, I wasn't concerned in that respect, and certainly felt that anything I did was capable of addressing any wider issues there.
Well, what about if an internal complaint or report had been made to the TSG to try to root out this sort of behaviour? Did you see that as any part of your role as a member of the Metropolitan Police Service?
No, that wasn't part of my role. I mean, had I been asked, I might have had a view, but I had enough on my plate.
Was there any sense within the SDS that it was better to cover for fellow police officers, even if their behaviour fell below the standards expected, rather than shine a light on it?
No, actually, there was more empathy and support for what I wanted to do than I had any interest in doing.
The question was about whether the culture of the unit, the SDS, was such that it was thought better to cover for a fellow police officer whose behaviour had fallen below expected standards, rather than shine a light on it. Was that the culture of the unit?
No, quite the opposite. It was, I would say, the culture and views and of people selected to do that work did not fall into that category of putting bad conduct or protecting bad conduct.
Well, then why not, at the very least, prompt some sort of internal report so that appropriate action could be taken against the officer who had done this to you?
Because on balance, I didn't think it merited it. I could have walked. I agitated the situation on balance. Might have overstepped the mark a little bit, but sort of all's fair in love and war was the view I took, and I did get better. And it wasn't outside of that sort of particular moment. It was nothing particularly egregious that I hadn't sort of brought upon myself in a way.
Right, so am I to understand that you didn't consider that a police officer causing a hairline fracture to the rib of someone arrested who was not physically resisting arrest to be worthy of note?
Yeah, it could have been, but on balance, when set against the huge complication and additional process and machinery that would invoke, with everything else I had to manage, it just didn't stack up.
What would have been complicated about Detective Chief Inspector Edmondson walking through Scotland Yard and speaking to an officer in charge of the TSG to say one of your officers has just fractured the rib of one of my officers?
Well, it's never as simple as that. That would be the result of a witness statement and a whole sort of an additional bit of machinery with possible repercussions for the officer involved. I don't think he actually set out to do what he did. So on balance, it was, this is an isolated incident. I'm going to get through it. And I'd rather just forget about it, but just, if you like, enjoy the sympathy and the empathy for what I'd been through from friends, in inverted commas, on the other side of the fence.
And leave open the risk that some other arrested person might be assaulted in a similar way by the same officer in the future?
Well, I don't think he set out to cause that injury.
He didn't accidentally fall on you, did he? It was an intentional act on your description of it.
I can't, yeah, I mean, that was a decision I made. I can't get any further in this conversation. I wasn't there to sort out the whole of the Metropolitan Police while deployed doing other things.
When you spoke to Operation Hearn in 2014, and perhaps we'll get it on the screen, MPS 0727448, page 5, please. And the section headed arrests, please. The date is slightly wrong. It's 1995. Sorry, I'm grateful. It's your A2, sir. HM1, the second of these listed, it has the date slightly wrong. It should be the 16th of March 1996, in fact. But it records an arrest for breach of the peace, and you saying this was useful as I got to spend more time with a particular target, spending a night in the cells with him, augmenting my credentials in their eyes. We basically became leery with the police officer and were locked up until we calmed down. This helped cement my relationship with him. And then this was a demonstration against the fur trader Hockley. On this occasion, I received an injury on duty, damaging my ribs. That gives the impression, in the way it's recorded by the Hearn officers, that you didn't mention that the cause of your injury was an assault by a fellow police officer. Did you mention it to them?
Yeah, no, most certainly, and we had a similar conversation to the one we're having now, as to what happened next, as it were.
So no reticence in mentioning that to Operation Hearn?
No, not at all. No. There was nothing to be remotely reticent about.
This document records that you spent the night in the cells with a particular target. Is that accurate?
Well, we certainly spent the most part of the evening and were let out later on that day, by which time it was dark, I recall, and I did end up in a cell with Greg Avery.
And you refer to that augmenting your credentials in their eyes. Again, was that seen as a benefit of being arrested?
Well, there's certainly camaraderie that is naturally established sitting in a police cell.
And was that seen as a benefit from your arrest?
Yeah, I mean, any camaraderie in establishing of a relationship and a sort of bit of credibility of having sort of shared that frontline experience is always going to be something that's worth talking about.
You mentioned when you were answering my questions earlier, your associates in the field and their response to what happened to you on this occasion in terms of your injury. You weren't the only SDS undercover officer who had suffered, if I just use the term rough treatment to cover a host of scenarios, rough treatment by arresting officers, were you?
Well, I'm sure not, but could you remind me of which ones I might know about, if that's what you're asking me about?
All right. Well, I'll ask you particularly whether you ever heard of John Dines being assaulted after his arrest during the poll tax riot. So it would be slightly before you deployed, but whether you ever heard of that.
Sorry, yes.
When you were in the field, for example.
Yes, yeah, the John Dines, that part of John Dines' history absolutely was talked about.
And was it spoken about in the sense that there was a pattern of that sort of behaviour by arresting officers?
Not in my presence. I mean, it was history for me from the very first moment I heard it.
Could we have on the screen, back on the screen, please, MPS 0246208, your B151, sir. This is the clip of documents from Detective Chief Inspector Edmondson. And can we have a look again, please, at the welfare section? The second paragraph records that you were debriefed more comprehensively at the Monday afternoon meeting, and it goes on as follows. And indeed, his colleagues were able to share in the event and those other rather light-hearted points which will always emerge at such debriefings. Does it follow from that all of the other field officers, at least those at that particular meeting, would have heard of the circumstances of your arrest?
I think in general terms, yes.
And was that usual that you would hear about that sort of thing if others were arrested?
Well, it was an exceptionally rare occurrence, even amongst the whole squad, if you like, such as it was for anyone to be arrested.
Right, but albeit rare, was it something in your experience that was shared amongst the squad when it happened?
Well, I've got to say, apart from myself, I don't actually recall any sort of news being made in that setting of somebody else's arrest, to my knowledge. So it was that rare, and so it was too rare for there to be a pattern.
Right, we know, for example, that Andrew Coles was arrested at a hunt-sabbing event in November of 1994, whilst you would have been deployed. Do you recall hearing about that?
I don't recall it, but yeah, obviously it happened. I don't recall whether it was mentioned or whether it was spoken about.
The reference to other rather light-hearted points which will always emerge at such debriefings, was your arrest treated by your fellow officers as something light-hearted?
No, that's a reference to me sort of making light of an event I wanted to make light of within a sort of comfortable space. It's just sort of what I was alluding to earlier. I could have walked away. Why didn't I? These things happen. That was a sort of light dialogue that's a reference to. It was nothing to do with anyone treating the event itself as with indifference.
Given that you've told the inquiry that you sought to avoid arrest for low-level matters, not to be seen as a hothead, why did you not just walk away from St John's Wood tube station and avoid confrontation with the police on that occasion?
Yeah, good question, and I'd rather I had done. So it's just one of those those spontaneous moments. I don't think that sort of undermines in any way that general posture of not doing that. I mean, it only happened twice within my time there. So most of the time I did avoid, would walk away. So exceptionally rare, but I absolutely agree. Should have done, and would almost rather I had done.
You were arrested twice, but are you sure that it was only twice that you were at the front of this sort of event rather than hanging back?
Yeah, absolutely.
Or is it the case that you were somebody who presented yourself as more willing to get involved in this sort of activity that carried with it a risk of arrest than you have told the inquiry?
No, absolutely not. The frontline, sort of skirmishes, confrontation was just not me.
Could we have a look briefly, before I move on, at the custody record in your name that was kept by the police, MPS 0746164. It's your B147, sir, page 3. And can we, thank you. The entry at 8 p.m, 2000 hours, checked, correct, I think that says, if I'm not mistaken, meal offered, delivered, stated he was vegan, that told he would have to wait for food, I was told to fuck off. Is that how you behaved to the police officers in the police station?
I don't remember using that language. I don't know whether that was, Greg's language or not. But that conversation, yeah, I did have to decline food while waiting for vegan, which was, I remember doing that for sure.
Is it possible that you felt aggrieved, having been assaulted by the police in the back of the van, aggrieved enough to react in that way?
No, and I do remember this though. I tell you what I did feel aggrieved about. I was at that point very, very hungry indeed, and the idea of turning down a vegetarian meal while having to wait for vegan was not a happy place.
Not easy in 1996 to get a vegan meal in police custody.
No, absolutely not. Not sure how easy it would be now, but anyway, it was just the fact that having to wait for something. That's what I remember most about that evening.
Could we take that down, please, and go back to the notes of Detective Chief Inspector Edmondson, MPS 0246208. That's your B151, sir. And at the bottom of page 1, if we can have the bottom half of the page, please. Mr. Edmondson expressed himself as satisfied that you had acted quite properly within the terms of your SDS operation and that your standing within your target group remains high. It then says this, albeit some wiser heads found it amusing that he could not avoid arrest for this relatively minor offence. Do you understand the reference to wiser heads to be a reference to people within your target group?
Well, don't know actually. Whatever it is, I mean, there were people that did find it within that target group, as you put it, surprised. But I'd found myself in that situation and hadn't walked away from it. So that's certainly accurate. I don't know what was meant by Keith Edmondson when he wrote it.
Is there any possibility that that refers to your colleagues in the SDS, the wiser heads?
I doubt it. I don't know how those wiser heads would have got to that conclusion. And it wasn't a world that many of them were familiar with.
Do you recall there being any amusement from your colleagues that you had not been able to avoid arrest?
No, there wasn't amusement. I mean, I think people could actually see, to be fair, as I recall, it was quite difficult to conceal the pain. It was that classic sort of rib injury that every time you breathed on it at that time was at its most painful.
I'm going to ask that we turn to page 3, but before we do, just remembering that on the 20th of March, the view was that your standing remained high in your target group. Could we have a look, please, at page 3 of this clip of documents? And a note on the 26th of April, so just about a month and a bit on. And you had been on holiday with your wife. You had continuing discomfort in your ribs and a hairline fracture had been diagnosed. Mr. Edmondson appears to have provided that information on to those in the police, the medical branch. And then the third paragraph says this: apart from that, HN1 is in his usual good spirits, albeit he has been involving himself fully in ALF activity of late, and he is a little concerned about some around him being arrested or presumably at least receiving home visits and searches by the police. It may be that we will need to devise a cunning plan regarding this, but we will have to ensure that we have control at all times. That idea is being considered, and any outcome will be noted. When the note records that you had been involving yourself fully in ALF activity of late, what is it referring to?
I think that's a generic description of my day-to-day engagement and association with the group.
But your day-to-day life as Matt Rayner didn't involve daily ALF activity, did it?
No, I think it's a loose bit of language that describes just a continuation routinely of everything that I've done up to date. That's what it describes.
Is that right, or is it reflecting an increased involvement by you in ALF activity by this point in your deployment?
No, but it does reflect, I think, a closer association with those that are.
Isn't the definition of ALF activity, in the eyes of the SDS and of you at this time, illegal activity?
So I didn't write that. I think it's lazily put. I know what was meant by that, which I've attempted to describe. As I say, I didn't write that.
What did you tell Keith Edmondson you were up to?
Well, Keith Edmondson and the team had day-to-day, week-to-week visibility of what I was up to.
But they couldn't actually see what you were doing. They were reliant on you to tell them, weren't they?
Yes, absolutely. That was the case from day one.
So what were you telling them you were doing in around April 1996 that might have led to the record suggesting that you were involving yourself fully in ALF activity of late?
Well, I think if you put together everything that we've spoken about over the last few days, that's a pretty good picture. In fact, that is the picture.
As I've understood your evidence over the days that you've been giving it HM1, it's that whenever there was the prospect of criminal activity that might lead to arrest, you stood back from the core of it and avoided getting involved as much as possible. Have I understood that correctly?
Yeah, that's absolutely, that was the balance I struck, yes.
That's not consistent, is it, with involving yourself fully in ALF activity?
Well, ALF activity is a broad church. Support for involvement in groups that are supportive of such activity falls within that broad church.
Right, but it doesn't say involving himself fully in supporting ALF activity. It says involving himself fully in ALF activity.
Yeah, as I say, I didn't write that. I think it's lazy language for the sake of brevity.
Are you quite sure that it doesn't reflect an increasing willingness on your part as your deployment came towards its end to involve yourself in illegal activity connected to the ALF?
No, that's not what it's. That's not the significance of how that's written.
The reference to your concern about some around you being arrested or at least receiving home visits and searches by police, that does indicate, doesn't it, that those with whom you were associating were at least suspected of being involved in criminal activity.
Yes.
And the reference to devising a cunning plan regarding this, was that something that you were involved in discussing at this stage? Were you aware of that as a consideration?
Not at that time, but then it was discussed subsequently as to this might be something that would enhance credibility.
And the need to enhance your credibility was because you were associating with people who were getting arrested, were receiving attention from the police in connection with their activities.
Yeah, it was this whole concept of if that type of thing is happening to others, how is it that it hasn't happened to you yet? I mean, it wasn't spoken about all the time. It was just an aspect of what enhances the journey, if you like.
In order for it to be worthy of remark that you were not being arrested and not receiving police attention, you must have been representing yourself as somebody who might do something worthy of police attention. Does it not follow?
Well, people were the subject of attention, not necessarily post fact. It was with regards to intelligence identifying activity which falls into that support for, involvement with, conspiring to a whole range of broad church type activity linked to the sort of generic self-acclaimed, self-avowed support for ALF activity. Up and down the country, that was sort of routine police investigative work, and people were being the subject of attention through search warrants, for example. That's what the genesis of this discussion was. So it wasn't hatched by me. It was presented to me as whether this was something worth exploring.
And presumably you agreed it was worth exploring because we know that there was a sham search of your cover address in due course.
So as the conversation unfolded, we talked it through, and it seemed to me that was a worthwhile venture.
On the last occasion you gave evidence in January, one of the individuals you compared yourself to in terms of your outlook and how you presented yourself was Paul Gravett. All right, somebody who was vocally supportive of ALF direct action, but who didn't indicate any willingness himself to take that action. Do you recall giving evidence to that effect?
Yes, absolutely. In my time, that was absolutely how I saw him.
And so if Matt Rayner was somebody who offered vocal support for ALF activity, but represented himself as somebody not willing to take criminal direct action in support of it, it wouldn't be surprising if that person was never arrested, would it?
No, but it wouldn't be surprising if they were, depending on what other information was in the system that might give cause for that type of action. I think the other aspect of this was it was deemed to be quite a useful event, which could then be exploited either way. One, need to be quieter than before, need to be more careful than before, and so it was quite useful in terms of the versatility from which it could be deployed subsequently.
Just to make sure I understand that answer, you're suggesting that after a search, it would give you an excuse to stand back from activity?
Well, it gives one the option to deploy that line. Yes, and all sorts of risks as well. I mean, it was a balance of the positives and the negatives, and the complications of actually doing it as well.
Did you foresee, as at April 1996, that you might come under any pressure to involve yourself in serious criminal activity, such that it would be useful to have this tool?
Well, it was useful to have the tool from a point of view as a little bit of credibility or enhancement of credibility, but also that additional, if you like, range of options. And I was more associated with people that were engaged in that type of action. So it was just, I say, it was part of the journey. It wasn't with a view to any sort of strategic, finite part of the operation.
Let's have a look, if we may, at a document the inquiry found alongside the search warrants that were obtained in May 1996. It's MPS 0746156, and it's your B150, sir. And what this appears to be on its face, HM1, appearing alongside the warrants, is at least a version of information being prepared for submission to the court in support of the warrants that were issued. Do you follow?
Yes.
And if we just step back for a moment before I ask you to look at the detail of this, do you accept that the whole premise for an application for a warrant to search your cover address and vehicle was false because you weren't in fact a real person?
Well, I wasn't involved in the wording of this or the drafting of the case for a search warrant, but the whole nature of the undercover operation was that I wasn't authorised real person in that identity.
But the court was going to be misled, wasn't it, necessarily?
I had no involvement in how that aspect of the application was dealt with at all.
Can we have a look at the detail in this document, please? I want to go through it paragraph by paragraph. So can we start with the first three on the screen, please? Right, it says information has been received from a well-placed source who has proved to be very reliable in the past concerning an individual who has been responsible for threats to damage property and criminal damage. Inquiries made have established that the individual so named is resident at the aforementioned premises. These are references to Matt Rayner in context. This individual has been identified as a known animal rights activist who has been in regular attendance at protests against the animal trade and against people allegedly involved in the animal trade. Two of the subjects of animal rights attention of late have been the wholesale fur outlets in central London and the chicken slaughterhouse in Leyden Street, London E1. The first paragraph is suggesting that you have been responsible for threats to damage property and criminal damage. Is that accurate?
Well, I think if you read the whole thing, I mean, it talks about all of that activity that is taking place. I haven't read the whole thing, by the way, but I can see what's being said there. All of this activity is taking place in an association with protests against those premises. I have been present, as we've discussed many times these last few days. So which I never denied.
Had you been responsible for threats to damage property and criminal damage?
No.
So to that extent, this information to be put before the court is false.
So can we read the whole? Can I have the whole thing back up?
Yeah, sure. We'll read through the whole thing and then I can come back. If we have paragraphs 3 and 4 on the screen. Sorry, so the one starting in March 1995, please. I haven't read that one, thank you. In March 1995, a burglary was committed at the Leyden Street slaughterhouse during which damage was caused and a list of company employees was stolen. Since then, the home addresses of a number of Leyden Street employees have been visited. On these occasions, the occupants of the addresses have been subjected to physical and verbal abuse. They have also had damage caused to their property. Those paying the visits have been masked and have decamped prior to the arrival of police. During the first quarter of this year, the situation has escalated. The most recent incidents involving the slaughterhouse employees occurred on the 21st of January 1996. A Granada motor car belonging to an employee of the slaughterhouse was criminally damaged by what was believed to be animal rights activists in the vicinity of the premises. Then, on the 20th of February 1996, an address in Mostyn Avenue, Wembley, Middlesex, was visited by about 8 balaclava-clad individuals who demanded to see the occupier's son, who is an employee at the chicken slaughterhouse. The occupier, who is a 76-year-old widow, was caused great alarm and distress by the threatening manner of the group, who stated that they intended to get her son later. The group, having left the premises, then returned and sprayed in paint the words scum and murder across the front door and walls of her house. They also posted disturbing literature through her letterbox and those of her neighbours. Can we have the next paragraphs, please? The final three, please. Thank you. In addition to the slaughterhouse campaign, the London fur trade has been the target of many damage attacks, including one which took place during the night of the 12th to the 13th of March 1996. On this occasion, a motor vehicle belonging to the wife of the manager of Hockley Furs was criminally damaged by having paint daubed all over it. The information received is that the occupant of the aforementioned premises is responsible not only for taking part in acts of criminal damage, but also in targeting victims. He is also responsible for recruiting others to commit the offences with him, and the occupant of the aforementioned premises, for the avoidance of doubt, is you, the subject of the warrant to be. The purpose of the application is to search for evidence which will prove his connection with these offences. This evidence will, it is expected, include articles for use for causing criminal damage and correspondence which will relate to the targeting of victims. It is also expected that evidence will be found in correspondence form which will assist in proving offences committed by others involved. Do you accept, looking at that document as a whole, HM1, that the impression given is that you were involved, Matt Rayner was involved, in these incidents?
Yes.
If we could look then at that penultimate paragraph, it also suggests, doesn't it, that you had taken part in acts of criminal damage and also targeting victims, had you?
No.
So this information makes false assertions in support of the application for a warrant on the face of it, doesn't it?
On the face of it, yes. As I say, I had no part to play in the drafting of this document, never seen it before, but yes, I agree.
And it asserts that you were responsible for recruiting others to commit offences with you. Were you so responsible?
No.
Can you think of any reason why it's asserted there that you were?
No. As I say, I wasn't privy to the process underway that had this draft going into the system.
Did you understand that an application was going to be made for warrants to search your cover address and vehicle?
Yes.
What did you imagine would be the basis for such an application, if not a suggestion that you were involved in crime?
Well, by association, I mean, if you take the generic description of what was going on, as described in that application, which is all correct, association with, through it being acknowledged that for the mainstream demonstrations I was there, I was taking people to, being spotted, was regularly present and was quite prominent on the scene. I could see how you could get there as to interest by investigators as to whether more would be found, linking me to some of those allegations.
If your only role was to drive people to demonstrations, that wouldn't be enough to found a warrant, would it? Investigating you for involvement in criminal damage attacks or targeting victims.
Well, look, so allowing for the fact that this is, by definition, something created for the use of an SDS officer within the system, that would absolutely be enough to actually prompt the need to do more than hitherto had been an investigation up to that point. So regardless of the accuracy of the assertion that I am behind all of those events, needing to know more about someone associated very prominently and with other sort of forms of intelligence and reporting, identifying me as someone involved on the periphery would absolutely be enough.
Right. Could we have a look at the examples given and by reference to your reporting on the events? If we could have a look, please, could I have the whole document up and then look at the 4th paragraph that begins during the first quarter of this year? This paragraph refers to an incident on the 21st of January in which a car belonging to an employee of the Leyden Street slaughterhouse was criminally damaged. And can we bear that in mind and have up on the screen, please, MPS 0245867, an intelligence report of the 23rd of January of 1996. And we see a report reporting almost exactly what's in the information, that Gretchen and another identified a Ford Granada used regularly by employees of the Leyden Street chicken slaughterhouse. It was located and subjected to criminal damage attack by the pair. Is the information right or wrong in suggesting that you were also involved in that criminal damage attack?
Well, it's wrong because I wasn't.
Are you sure about that?
Yeah, positive.
Could we go back, please, to the information MPS 0746156? I don't know if it's possible to keep that document on the screen whilst we bring up the reports. It might save going backwards and forwards, but I'll leave that to whatever's easier, side by side, if that's possible, and then that will save you jumping around. We can take that report down now, but have a backup at 0746156 and keep that on the screen if we can. Thank you. Thank you. And can we go back, if it's possible, to zoom in on the left side document 0746156 on the large paragraph during the first quarter? Thank you. The other incident referred to in this paragraph, HM1, is on the 20th of February. An address in Mostyn Avenue, Wembley, Middlesex, was visited by about 8 balaclava-clad individuals. Could we zoom out of that, and if we can have on the screen next to the information, MPS 0246237, a report of the 23rd of February 1996. Can we get rid of the report on the right-hand side and have in its stead MPS 0246237, please? Thank you. HM1, this is a report of the events of the 20th of February, visiting a surprise home visit as it's described. And it describes the visit in paragraphs 2 and 3. Could we have those up on the screen, please? Thank you. As this, the activists met at Privacy Station before going to Privacy. Once in the street, the activists leafleted neighbouring houses. Having done this, a small delegation went to the door and asked the elderly woman occupant where Privacy was. The elderly woman, visibly shaken by the presence of sinister visitors, said that Privacy would not be home until the following night, although she said he would be at work at Privacy the next day. Satisfied that they had the correct address and that Privacy was not there, the activists adjourned to a nearby pub. During the ensuing period, a small group of activists, including George and Privacy, returned to the address and painted slogans on the walls and windows there. If we compare that to the information in the document headed information, can we take that down? That says that 8 balaclava-clad individuals demanded to see the occupier's son, and that the occupier, a 76-year-old widow, was caused great alarm and distress by the threatening manner of the group, who stated that they intended to get her son later. So slight differences in terms of the description of what went on and the effect on the individual. Are you able to say whether your reporting is more accurate or the information is more accurate?
Not specifically. I mean, I do remember it as being. I mean, look, this was a particularly nasty event. I do remember the elderly person being shaken, however it's described. So I've got no particular recall of this event as to whether people at the time were put balaclavas on or not. But the event certainly took place.
Well, you were present for it, weren't you? We see your cover name at the bottom of the report.
No, absolutely, yeah. No, we absolutely went there collectively, yes. I just don't recall the specific bit about balaclavas.
Right. Were you a balaclava-clad individual?
No, I've never worn a balaclava.
Can you think of any reason why the information put before the court would assert that if it were not accurate?
No, and I don't know that it wasn't accurate. I just don't recall that, and I see that I hadn't put that in my report either. So.
No, the report doesn't mention that at all.
No.
The report attributes the painting of slogans on the walls and windows to George and another. The information says that the group returned to spray paint across the front door and walls of the house. Again, is it more accurate to suggest that it was just George and one other, or was the whole group involved, including you?
No, the whole group wasn't. Elements of them were.
Can you think of any reason why, when the information or when this detail reaches the document headed information, it's suggesting that the whole group was involved?
No, I can't, but it's not inaccurate to say, elements of the group.
Well, it doesn't say elements of the group, it says the group.
No, it doesn't. As I say, I didn't draft it, and I didn't see it, and I didn't corroborate it.
Could we have a look, please, if we take down the report on the right-hand side of the home visit and focus back on the information, please, on the left-hand side. It also asserts damage to the car or the vehicle belonging to the wife of Mr. Hockley in the 5th paragraph. And can we have up, please, the report 0246076, MPS 0246076 of the 15th of March 1996. That's your C441, sir. And this report on the right-hand side now, referring to Wednesday the 13th of March, so the same date, reports that a car believed to belong to Hockley was sprayed with red paint. Gretchen and Privacy apparently saw him driving the vehicle last week. In addition to the paint attack, it's believed they may have sent a letter to Hockley threatening, or Privacy may have sent a letter to Hockley threatening further action. Were you involved in this criminal damage attack, or is the information wrong to imply that you were?
Well, I wasn't. I wasn't involved.
Are you sure about that?
Yes, positive.
Can you offer any explanation for how these particular incidents came to be included in the application for the search warrant, or was that nothing to do with you?
Yeah, I'm afraid that's my constant reply on this one. I say I wasn't involved in the drafting. I didn't see it, wasn't able to corroborate or even sort of suggest amendments.
Could we just go back, moving away for a moment from the information itself, and go back to this home visit that took place in Mostyn Avenue in Wembley in February 1996? Could we have on the screen MPS 0245910? That's your C425, sir. And can we focus on the main body of the report? Thank you. It's dated the 6th of February, HM1. And in short, it's a report in advance that the visit was to take place. So George is becoming increasingly frustrated with the lack of progress in his crusade against the Leyden Street chicken slaughterhouse. The 3-year campaign has reached new heights of acrimony. And then paragraph 2, in devising new tactics, George has decided that the 20th of February will be a day on which activists pay a visit to the home of one or more of the slaughterhouse staff. In addition, he's planning an ALF-style liberation raid on the slaughterhouse, etc., etc. But we see their reference, at least, that the 20th of February has been selected as a day for one or more home visits. Is that right?
Yes, that's right.
And the heading indicates that this information was known to very few trusted activists. So that suggests that you were amongst a very small group, does it not, who
Yes.
knew about the information in this report?
Yes, absolutely. Although George was very sort of vocal, quite sometimes spontaneously, as to his intentions and plans for events such as these.
If we take that down, that's a report dated the 6th of February, and can we put on the screen, please, MPS 0245964. It's your B143, sir. And this is a document created by management, not by you, on the face of it, HM1, dated the 15th of February 1996. And can we, it's headed the Leyden Street Chicken Slaughterhouse campaign, but can we have a look first of all at paragraphs 1 and 2, just to set the scene. It sets out the history of the Leyden Street Chicken Slaughterhouse demonstrations, that George is the main campaigner, that there have been monthly pickets and on occasions confrontations, and that the atmosphere has been more tense. It references to damage to a car from activists, which we've looked at reporting about that, and then retaliation and scuffles breaking out at pickets in retaliation. At paragraph 2, we needn't touch upon, but it's George said to be recruiting a new ally. And then can we have a look, please, at the following paragraphs? 3 and 4 and 5, please, actually. Thank you. There's reference at paragraph 3 to a change in the demonstrations, and then also what has not been reported or communicated to CE Squad is the intended target for the subsequent home visit. The target is privacy of Mostyn Avenue, Wembley. This has not been communicated because there can be no guarantee that to do so would not result in police action, which would be detrimental to the safety of HN1. HM1 will be taking part in the home visit, which is not likely to result in criminal acts against privacy or his property. So what we see there, taking it in stages, is that it appears that by at least the 15th of February, so 9 days after the written report certainly, you were able to say that the target for the home visit would be this address in Mostyn Avenue in Wembley. Is that right?
Yes.
And are you able to say why that doesn't appear in your written report? Is it because the decision had been taken not to communicate, not to disseminate that detail?
Well, looking at that, yes, that is the explanation. Yeah.
Were you consulted or informed about the decision not to communicate or disseminate the target for this visit more widely?
I don't know if we had that conversation on this specific one. It would be, there was always a conversation about how many people know about sort of duty of care to the subject of the protest and the likelihood of anything untoward happening.
Did you know when you went along to the visit that the wider police community had not been alerted in advance?
No, I didn't know whether they had or whether they hadn't. I always was happy to leave that decision to the office.
The suggestion made here is that the reason for not communicating the target, the precise address, is because there can be no guarantee that it wouldn't result in police action detrimental to your safety. Do you understand what that means?
Well, if it was genuinely felt, and it could well have been at the time, that this really was only known to those on an invitation list attending, I think it was that's part of the balance of protecting the originator of the information, in this case me.
So when it says safety, would it be equally accurate to say detrimental to the operational security of your deployment?
Yes.
So to ensure that you were able to maintain cover and not fall under suspicion would be
Yes,
another way of putting it.
Yeah, as part of that articulation, yeah.
The assertion that it's the home visit was not likely to result in criminal acts against the individual or his property. We know from your report after the event that there was damage by painting slogans on the house. Was that not foreseen as a possibility?
Yes, in my mind it always would have been. I don't think on those home visits I ever committed to a line that criminal damage was anything other than a possibility.
So do I take it from that you would not have asserted that the home visit was not likely to result in criminal acts against the individual or the property?
For that type of event with those individuals, I would absolutely not have asserted that.
Because in order to daub slogans with paint, one presumably needs to turn up with the paint. So there's an element of planning.
Well, even without any knowledge of that in advance, it was just knowing how those home visits go, the level of vitriol on arrival, and even if not planned, the spontaneous, emotion can easily lead to unplanned events. So even with the lack of planning and intent, I would always include on visits such as those the possibility of it spilling over into acts such as those.
But one can't spontaneously daub paint unless one's carrying paint around.
No, I'm not talking about the paint specifically. I'm talking about the assertion that it's unlikely that criminal activity. It's unlikely that criminal activity will take place. I would always add the proviso that it could well do, whether planned or otherwise.
And on this particular occasion that you attended, were you aware that those attending were taking paint with them with a view potentially to causing criminal damage?
No, I don't think I was at the time. I don't think that had been spoken about specifically, not in my presence.
Right, so do you remember that coming as a surprise to you?
Well, I mean, all those sorts of things, just from past experience, have a habit of appearing, or had a habit of appearing up and down the country. So that in advance, it wasn't specifically that's going to be the plan of attack. So no, I wasn't present when any such conversation was had, but recognising that on the day, anything could happen.
I think you've described elsewhere George as being somebody you regarded as having a volatile temperament and being unpredictable, sometimes taking action without really consulting other people. Is that right?
Yeah, I think that was not just my view.
Looking at it now, was it not risky not to alert the local police in the circumstances to this home visit in advance?
Well, I say I didn't know that they hadn't been. So when it's a balance, isn't it? With hindsight, another part of the risk mitigation is to brief the intended subject of the protest, that there's likely to be some form of protest at the house and not to be there. And I don't know whether that was done or not.
Well, based on this document, the address wasn't communicated even to CE Squad. So it appears, doesn't it, that the intelligence wasn't disseminated, this particular piece of intelligence, the address, wasn't disseminated anywhere outside of the SDS.
Yeah, reading that, that's how that reads, yes.
And so does it follow that this is the SDS taking a decision internally that it would take a risk in terms of the safety of the property and the individual concerned in order to safeguard the continuation of your deployment?
Yes, on this occasion, I mean, that was a risk that they were mandated to own and regularly, regularly balance that type of risk.
When you say they were mandated to own the risk, was there any written policy or guidance that you were aware of that gave them authority to take those risks in order to maintain the cover of their field officers?
I don't know whether there was written policy or indeed where that was, but it was a structured outfit with senior command all the way to the top that had vicarious liability for ownership of that risk taking and articulation of why it was taken in the way it was.
Right. Could we take that down, please? And I want to look a little more at the management documentation around this time. Could we go to MPS 0730114, please? It's your B154, sir. And HM1, this is a file note which on its face shows Bob Lambert as its author. And it's dated the 20th of May, 1996. So the document we were looking at in which Keith Edmondson referred to there being a cunning plan or thoughts of a cunning plan was back, I think, in April. And now in May, this is a note drafted by Bob Lambert. Could we just zoom in on the top half of the page, please, above the redaction? Thank you. Right, so a document, again, referring to the fact that you had come under suspicion from George during the first year of your deployment. And it says this: during the intervening period, HM1 has got on reasonably well with George, but there has always been an underlying tension which appears to have been exacerbated by the fact that HM1 has won the confidence of leading ALF activists in London and elsewhere, and George has not. And then there's a paragraph about why certain activists who listed there do not trust George because he's excitable, indiscreet, etc. And then paragraph 3 describes George as the leading organiser of the long-running Leyden Street chicken slaughterhouse demonstrations. And then it says this: it was on a recent Leyden Street demonstration when HM1 managed to incur the wrath of George. Again, this was a personality clash, and one where the bulk of activists concerned have sided with HN1. However, it leaves George angry and determined to undermine HM1 if he can. Do you recall what that is referring to?
Can you remind me of the date of that?
Yes, it's 20th of May 1996, so within the last 6 months or so of your deployment.
Oh, okay. No, not specifically. There were many such occasions. where I don't know what that particular altercation was. If you're asking me about that specific bit.
Yes, I was wondering if you could assist as
but
to
in
what
Curtis
it
lost.
is.
No, by '96, I'd lived for 4 years with his, I guess, his views on me, and dislike in a sense, and that anything when we were close to each other in geography was likely to be antagonistic for him. So I can't remember what that specific. Had it been earlier, I mean, there was one incident where he assumed my temporary disappearance to go and get coffee was, I think, associated with phoning the police, and used that as a sort of one of the strands as to why I might have been, well, at that time a journalist or something other than what I was purporting to be. I can't, no, so as late as '96, I don't remember that specific saga. It would have been one I lived with for over 5 years.
Right, so this was a recurring theme, fairly low-level incidents.
Well, look, it was almost. I mean, it was a sub. I mean, so many people by then were talking about it, about the two of us as having just not got on for long periods of time, albeit that we'd actually been present and at events together.
Could we just have a look at page 2 of the document? Thank you. Just going to wait. I haven't put a paragraph reference. Just bear with me, please. Yes, if we could look, please. Just, it's the first main paragraph. We could look at the first 3 paragraphs, if we could zoom in on those. It says that you realise you have to tread wary to avoid the matter escalating. Would not be in your interest to engage in a long-running internal dispute which might backfire once you left the scene. And then it says instead he, that's you, is going to seek an opportunity to appease George on a one-to-one basis. It may follow from your lack of recollection of the incident itself, but are you able to help as to what appeasement of George you might have engaged in?
No, other than the occasional discussion as to attempts to almost sort of have this out one-to-one, whether, what are we going to do about this? Either sort of put up or shut up and type conversation. Those never really materialised, or when they did, they weren't entirely successful.
The document goes on in that 3rd paragraph. George's current allegations add impetus to a plan to enhance HM1's credibility by visibly linking him to an ongoing police investigation concerning criminal damage attacks surrounding the Leyden Street campaign. George, for his part, has been arrested for related offences in the past. More recently, however, Gretchen and Privacy have been questioned with regard to a criminal damage attack which took place at the home of a Leyden Street slaughterman in February. That appears on the face of it, HM1, to be a reference back to the 20th of February visit to the Mostyn Avenue address. And the document concludes, thus the intention has been to include HM1 in this investigation so as to enhance his credibility, but also to offset George's specific allegation or cause for suspicion, i.e. how come he never gets pulled in by police. Do you recall that there was a plan to link you specifically to a visit to the home address and a criminal damage attack at the home address of a Leyden Street slaughterman?
Sorry, a plan by whom to link me?
Well, this is written by Bob Lambert, so a plan by the management of the SDS to link you to a criminal damage attack that had taken place in February at a home of a Leyden Street slaughterman.
Not in connection specifically with the application for the warrant, if that's the question.
Well, this is a document drafted by Bob Lambert shortly before the warrants were executed, suggesting that the plan would, to enhance your credibility, would involve linking you to that specific criminal damage attack. Do you recall being made aware of that?
No.
Do you agree that it wouldn't make much sense to George or the other activists to see you arrested in connection with that criminal damage attack unless you had been sufficiently close to it to warrant suspicion?
Well, I don't think the plan was to let them know what the specific nature of what was going into the application for the warrant. It was a general, as in that statement. How do we get over that? How do we move forward for those? How come he never gets pulled in by the police? Type assertions. It wasn't Leyden Street specific.
Right, but wouldn't you expect to be asked after the event by your fellow activists what were you arrested for, and to be able to give a credible answer?
Well, yeah, no, that did take place. I mean, the whole purpose of the subsequent search was to be able to talk about it.
And was the reason that you gave them that the arrest was linked to a home visit in February at which criminal damage took place?
I don't remember singling that out in my explanation to anyone. It was more the wider interest me as someone that was on the scene, that someone that they now wanted to know more about.
So, if asked after the event, you were simply to tell your fellow activists that the police were just generally interested in you as someone on the scene, rather than arrested in connection with a suspicion that you had been involved in a particular offence?
No, it was for me. It was for me to use as I saw fit. I mean, everyone that knew me by then knew I was on the scene and associating with people that were being the subject of interest or arrested or the subject of search warrants. So there'd be nothing unusual in terms of where I was for me to be next in line, if you like. But it wasn't for me to shout from the treetops about the fact I'd been arrested. It was for me to use discreetly as to what had happened. But the fact was it had happened. I could speak credibly about it.
But even if deploying it discreetly, you would be deploying it with fellow activists. Have I understood that correctly?
The explanation?
Yes.
Yes.
And those activists were themselves not strangers, some of them, to being arrested by the police, were they?
No, but it was, you're asking specifically about Mostyn Avenue and Leyden Street. No one's expected to talk to others that weren't involved in that type of activity about stuff that you might generally want to keep to yourself.
But those activists would understand, wouldn't they, that if you were arrested by the police would have to have suspicion, at least, that you had been involved in a criminal offence. That's right, isn't it?
No, well, yeah, I think yes, but the general view was, the police were pretty active, and most association with this generic ALF way of life came under police scrutiny in a way that regularly had people put under investigation and sometimes the subject of search warrants.
Is it not the case that if this was going to enhance your credibility, it could only work in that sense if the activists believed there were grounds to connect you with a criminal offence?
So, suspicion of engagement in activity, supportive of that type of activity. I think there's where we're sitting at the moment having this conversation is it's actually quite difficult to describe what was going on at the time in terms of the proliferation of this type of activity, which is more or less a complete thing of the past now. So it wasn't, these weren't odd bits of campaigning that had individuals only sort of arrested and incarcerated for serious arrestable offences. This was prolific activity up and down the country, responsible for economic damage, criminal acts, and in some cases quite serious criminal acts. So it was as prevalent as other extremist forms of action were, including Irish Republican terrorism, in terms of the level of interest and need to know what those associated with this course of action was. So it wouldn't have come as any surprise to anyone, even if it was just from my taking people to and from events, that I'd come under such scrutiny.
If you had told your fellow activists that you had been arrested by the police simply to inquire into why you seemed to be driving people backwards and forwards to demonstrations, would they not have encouraged you to take action against the police for an unlawful arrest?
Yeah, so that's not what I said I did. I was saying how they could quickly get there in terms of this knowledge of intense police scrutiny of what was going on at the time because it was so prolific, and the number of people being swept up into that sort of investigative machinery. No, it wasn't obviously just because I was taking people to and from, but it was certainly knowing that at events where we'd all been associated in different groupings, things were going on and people were being arrested. And I was by definition, geographically and almost sort of intellectually supportive of such activity. I mean, why wouldn't they want to?
Well, simply intellectually supporting such activity didn't necessarily lead to someone being arrested, did it?
No, that was on my list. I didn't just mention that in isolation. That was part of a list of things.
But none of your list, if I suggest HM1, none of your list includes anything that would give the police proper grounds for arrest, does it?
Oh, well, this wasn't an arrest. This was part of an investigation into those involved in support for organisation of, knowledge of this prolific type of activity.
All right. Well, perhaps we'll carry on through the documents. I'll just carry on with this document before the break. Further down on page 2, could we have a look from the paragraph starting DC McMoss down to the end? The paragraph now at the top of the page, beginning DC McMoss, in summary describes that he has made connection or made a productive working relationship with an officer in the case who's involved in the investigation of the events at Mostyn Avenue, who has already been responsible for the arrest and search of someone else's home address based on a photo fit relating to the criminal damage attack at Mostyn Avenue in February. And McMoss has worked out a way of securing the search of your address based on a warrant issued at the local magistrates' court to enable a full search of the address. And then it says copy warrant and draft information attached. So the draft information is what we were going through earlier. The search will be conducted by Detective Constable Charles Lindsley on the animals section, who has been fully briefed. And he will be accompanied by Wembley CID, who of course have no knowledge of the activist's true identity. That's your true identity. It is hoped that correspondence at the address will lead to an arrest and subsequent questioning at Wembley Police Station. So it was envisaged, wasn't it, that as part of this sham search of your address, you would in fact be arrested?
Yes.
It suggests that correspondence at the address would lead to your arrest. Was there a plan to place correspondence in your cover address that would link you to either the Leyden Street Slaughterhouse campaign or the Mostyn Avenue event in particular?
No.
Did you have such literature or correspondence at your cover address anyway?
Yeah, there were leaflets and paraphernalia associated with those campaigns. Yeah.
And did you discuss with Bob Lambert the fact that that paraphernalia was at your address and could be used as grounds for your arrest?
No.
Did you discuss that the paraphernalia was there with Bob Lambert?
No, I think he would have known that was sort of part of the furniture.
How would he have known that you had correspondence at the address sufficient to justify your arrest?
Because well, I don't know about justifying the arrest, but in terms of knowing and seeing how I was living, if not him, one of his colleagues had visited before.
So through visits to your cover address, it would have been known that there was material there sufficient to give grounds to Wembley CID to arrest you?
Yeah, I mean, it was absolutely known sort of that there was paraphernalia and leaflets and the odd poster that was part of the setup there.
Right, but we can see from this document that this officer from Wembley CID is the officer in the case investigating what happened at Mostyn Avenue. And the intention appears to be that when she turns up at your cover address, she'll have no idea that you're an undercover police officer. That's how it appears from this document, isn't it?
That's how it appears in the document, yeah.
And so if a decision were to be made by her to arrest you, on the basis of something found in your address, that thing found would have to be sufficient to give her grounds to arrest you, wouldn't it?
Well, it doesn't have to be quite as clinical as that. It could be enough in terms of whatever else that person has at their disposal to want to arrest me for further questioning.
What are you suggesting that Detective Constable Lisa Large might have at her disposal? I'm sorry, I didn't understand that answer.
No, I'm not suggesting anything. I'm saying that regardless of what is found during a search warrant, I'm talking about it generally here, is that's not the whole picture often. There will be things outside of what is found in terms of intelligence, other investigative material, which gives grounds for further questioning and arrest in connection with those with that questioning. It's not solely reliant on what is found in one's home address.
But on your evidence, Matt Rayner wasn't engaging in criminal activity. So what other grounds could there possibly be?
Well, I have no
right.
I have no part to play in the drafting of this warrant, but I will keep coming back to the fact that there would have been enough in the machine of people observing me, seeing me, reporting me up and down the country as a very present campaigner.
But being a campaigner doesn't give grounds for arrest, does it?
Well, no, in isolation, no, but campaigning with association for linked to groups who were unashamed in their commitment to the use of direct action in support of animal liberation, bringing the vivisection and the fur trade to an end. At the time, that would have been plenty. You could argue even, regardless of the fact that I was an undercover officer, that would absolutely have been more than enough.
Are you quite sure you weren't more involved in the criminal acts being carried out by your fellow activists than you are willing to admit to this inquiry, HM1?
No, I'm absolutely certain that I could not have been more sort of open and candid on this one.
There's one more point on this document. I'm just pausing to see if I can test the patience of the stenographer for a few more minutes.
You've got a nod.
Thank you. Could we just turn, please, finally to page 3, then, of this document? And at the top of the page, it is asserted, it would certainly be surprising were HM1 to complete 5 years in the ALF with only 1 or 2 public order offences to his name. Do you agree with that suggestion, HM1?
Yeah, I don't disagree.
Does it not seem at odds with what you've said about it being possible to carry out a long-term deployment, seeking intelligence about the ALF, and standing back and not involving yourself in their activity?
No, I don't think it contradicts that at all. There are ways of being involved that keeps one well away from the public order offence type arrest, and the more discreet support that nevertheless brings one into that category of action being taken against you.
But isn't the suggestion or the implied suggestion here that the arrest in connection with Mostyn Avenue will be helpful to you because it would be surprising if all you had done in 5 years was be arrested for a couple of minor public order offences?
Yeah, look, it's not categorical one way or another, and it's all contextual within, say, where in my case I was on that journey. And this, in terms of the search that we're talking about, I think that was deemed to be sort of commensurately proportionate to something that needed to happen that hadn't happened, and as a result of which people were asking questions. So it didn't have to happen, but strategically, it was a useful part of as a journey of it, as it were.
And useful because it would indeed be surprising for somebody to spend 5 years expressing themselves as a supporter of the ALF and not to involve themselves in any activity that risked arrest.
Well, not to have come to the attention in a way that can be spoken about, i.e. the incident we're talking about, search and arrest. I think that's, well, I don't think that's what we're referring to here.
Thank you. So can I suggest we take the break there?
Certainly. We'll break for 15 minutes.
HM1, can I check you can see and hear me?
Yes, thank you.
Could we have on the screen, please, the same document we were looking at before the break, but a later part of it? Thank you. So starting on page 3 and going over to page 4, there is an update to the note that we were looking at, which confirms that on the 21st of May of 1996, the search warrant obtained was executed and you were in fact arrested and questioned at Wembley Police Station. Do you recall being arrested and questioned at Wembley Police Station?
Yes.
This document asserts that you were arrested and questioned concerning your possession of correspondence which indicated your involvement in the Leyden Street campaign and gave rise to reasonable suspicion of possible criminal activity, viz. The targeting of slaughterhouse personnel. Can you be any more precise as to what it was you were in possession of that gave rise to reasonable suspicion of involvement in the targeting of slaughterhouse personnel?
Well, there would have been flyers for events. There would have been articles. So it was a high-profile campaign which featured in journals, articles in the ALF supporters group, magazine, paper. So yeah, plenty there with reference to my knowledge of associated involvement in. But mainly literature for sure.
But what literature that would have linked you to the targeting of slaughterhouse personnel, specifically?
No, I don't. Well, there's no literature linked to the targeting in that sense. But in terms of the slaughterhouse campaign being one that I was involved in through the regular picketing, is a good starting point, bearing in mind all the other associated activity which was taking place out of sort of public view, as it were.
This document is asserting that you were questioned about it. Do you have no recollection of what it was you were questioned about specifically in this regard?
Do you know, I really don't remember the questioning, but it would have been, in summary, very similar to the questions that we've engaged in about involvement in, knowledge of, role, knowledge of specific events, for example, the Wembley one. I have no granular recall, though, of question by question, but it was very similar to the type of conversation we've had.
But what basis would the Wembley CID officer have had for asking you about the incident at Mostyn Avenue or the targeting of slaughterhouse personnel more generally? What gave them the basis for asking you questions about those topics?
Well, I was involved, and I was involved in the London scene, and Wembley was the area that covered where I lived. It was, in my mind, totally justified.
The document here goes on to record that the operation was regarded as having gone extremely well. There had been a series of interviews with Detective Constable Lisa Large, and you were released on bail pending further inquiries. At the point at which you were released on bail, did you have any understanding of what might happen next in connection with this, at this stage, embryonic criminal investigation into you?
No.
Did you feel at all at risk of charge or prosecution?
No, I didn't. No, I felt this was a contained part of the operation.
And why were you confident in that? What did you think was going to happen next?
Well, I didn't give it much thought in that sense, other than this. It clearly was staged, and therefore there would have been a degree of control over what happened next. This was a series of questions, and questions which I answered and was fairly satisfactory way, to my mind, that wouldn't lead to any form of prosecution, regardless of its authenticity or not. And bailing pending further investigation was actually totally standard procedure.
Had there been any discussion in advance of you being interviewed about what you should say to the uninitiated Detective Constable Lisa Large in order to avoid her taking the investigation any further?
No. I do remember. I can't be certain. I really can't, and I never asked as to the degree to which she might have been briefed somehow.
The document, the first part of this document that we looked at before the break, indicated that she was not told
Absolutely.
your real identity.
Yeah. It did say that, yeah.
So what was there to guard against the possibility that she might take the investigation against you further towards you being charged?
Oh, well, I mean, I didn't feel a need to worry about that because I assumed that would have been, part of the containment strategy for the whole operation, as it were.
So that was for Bob Lambert and Keith Edmondson to worry about, as far as you were concerned. Is that what you're saying?
No, absolutely. Well, not just to worry about, but as part of the planning as to how this would end.
The second paragraph on the page records that a pickaxe handle was seized from your address. What was that doing there?
I recall having a baseball bat. I don't remember a pickaxe handle.
Was a pickaxe handle planted in your cover address in advance of the search? Can you recall whether that's
No.
what happened?
No, I really can't recall any pickaxe handling featuring at all.
If it was a baseball bat, what was that doing in your cover address?
Oh, just theatre.
What does that mean?
So my place had been burgled while I was living there, and so when people came round, it was for the theatre of, yes, if someone comes again, I'll be ready type theatre.
Ever for the theatre of, I'm an activist willing to do damage with this baseball bat?
No, for the theatre of protecting myself the next time somebody else comes in and damages my flat.
The final paragraph on the page records that at 7 p.m. on the day of your arrest, you were debriefed by Keith Edmondson and Bob Lambert and found to be in good spirits. His account of the interviews, formal and informal, with Detective Constable Large, helped confirm that she appeared to be entirely satisfied that he was the genuine ALF activist article. So whatever you said in your interviews, you maintained your cover, and that appears to have worked in the sense that she remained uninitiated. Do you agree?
Yes, I do agree.
Can you recall anything of the nature of what you said to her in the interview?
Not specifically, no, other than sort of answering her questions in a way that, I say it's very similar to the theme and the focus of our questions, specifically in regards to London-based activity.
So do you mean you were being asked about generally involvement in London-based animal rights campaigning or something else?
Well, I was there for a bit of time, so I'd imagine the whole, quite a sort of broad spectrum of activity was discussed. I just really cannot, I really cannot remember.
The document goes on to say you were treated well and fairly, your performance appears to have been equal to the occasion. And then this, he was able to phone ALF activist Aubrey Thomas from the police station, and he subsequently informed PJZ. If you need to consult the cipher list, please do.
Fine, thank you.
And other key associates, some of whom had to be alerted that their phone numbers, addresses had unfortunately fallen into police hands. Rather than the impression you gave earlier about this being something you might deploy if necessary, it appears in fact, doesn't it, that active steps were taken by you to alert ALF activists, as they're termed here, to the fact of your arrest.
Yeah, I did selectively, yes.
And when you did that, did they not ask you questions about what it was you'd been arrested in connection with?
Well, not immediately, no. It was more, I think, concern for how it had gone and what happens next.
And what about, other than immediately, did they not ask you what you'd been arrested in connection with, what the police were interested in?
Yeah, and absolutely. And I think it was in connection with that I mentioned, you know, some people's details in old-fashioned address books would have therefore now be within their records.
Yeah, because the activists who were engaging in criminal activities were themselves concerned about their own risk of being arrested, weren't they?
Well, generically, I think there was always that concern because it was happening.
And so if you had been arrested and questioned, there would have been some interest on their part to understand what it was the police knew and what lines of investigation the police were pursuing. Is that fair?
Yep, absolutely.
And so were you not asked to account for your questioning in the police station and what topics it had covered?
Yes.
And you were able to satisfy them, were you, that the questioning had related to something that justified you being pulled in by the police?
Yes.
Even though, on your account, Matt Rayner was somebody who didn't involve himself directly in criminal activity?
No, but by the time you've explained the broad range of questions, I mean, anyone would get there quite quickly as to why I might have been of use in attempting to answer them.
Could we look at the last part of the briefing note? Thank you. It says that after the debrief, you left for an all-night session with Brendan McNally. McNally saw the arrest as part of an Arnie-inspired campaign of harassment and monitoring of top ALF players nationwide. Another useful spin-off was that Mick Moss obtained details of a word-of-mouth anti-circus demo at Godstone, Surrey, and could thus disseminate fully without fear of compromising sources. Thank you. All in all, a very satisfactory outcome. Do you recall the all-night session with Brendan McNally that is referred to there?
Yeah, I do. I do recall a long conversation or a conversation with him separately at a can't remember where it was. There were others there, but I do remember us having a conversation separately for some time.
So on the day that you had, or the evening of the day that you had been arrested?
Well, but for that reminder, I wouldn't have got there as to it happened that day. But I certainly remember having that conversation with him, so not contesting it wasn't on that day.
And it seems from what's in this document, doesn't it, that offers his view on the arrest, that you must have discussed the arrest with, at least with Brendan McNally, that night.
Yes.
Do you agree with the conclusion on the face of it by Bob Lambert that all in all it was a very satisfactory outcome?
Well, it certainly appeared to have been, yes. I mean, I wouldn't dispute that.
Did you reflect on whether it was satisfactory for the Wembley CID officers who were effectively misled and had wasted their time interviewing an undercover officer?
No, I didn't reflect on it in that way. I just reflected it on as being something that had been carefully thought through and been conducted well, and I'd come out of it satisfactorily, and everyone appeared to be satisfied with the way it had gone. So it was for others to concern themselves with the degree to which people were going to be briefed or otherwise.
But we know from this document that the Wembley CID officer, Detective Constable Large, was not briefed, so she did not know that she was wasting her time interviewing you and searching your cover address. Was any thought given by you to the fact that you as a police officer were misleading Detective Constable Large? in this
well,
enterprise?
so I actually, so not proactively, no, I mean, sort of for others to worry about that and then because sort of philosophize as to whether she was being misled or not. But I did get the impression, though, regardless of what's been written down here and not being briefed, that she was privy to more than a cast iron sort of assertion that she hadn't been briefed. And I've got nothing to base that on other than a gut feeling from her interaction.
But what's recorded here in this document of your debrief at 7 p.m. is that your account of the interviews with her helped confirm that she appeared to be entirely satisfied that you were the genuine ALF activist article. So there's no hint there, is there, of you thinking she was in on it?
No, and I don't think it was categorically. I say there was just something that either during the course of that discussion or in a confidential briefing, I don't know, I can't put my finger on it, but I didn't overthink from your question, the sort of deception angle, because I didn't see it that way.
You saw this as a proportionate enterprise in order to support your cover. Is that a fair way of putting it?
Yeah, and I also saw it as there having been plenty of sort of serious people up the chain who'd factored all of these sorts of things in and wasn't privy to a degree of briefing or otherwise.
Could we take that note down, please, and look at a further note by Robert Lambert, now the 5th of June. So a couple of weeks later, it's MPS 0746153, your B157. So. And this completes the picture, as it were, HM1, as to what happened following your arrest and your being bailed. So can we look, please, at the text? It's got Bob Lambert's initials at the bottom and then Keith Edmondson's further down. On Tuesday, 4th of June, HM1 attended Wembley Police Station in accordance with his bail conditions. He was accompanied by ALF activist Privacy. He was interviewed by Detective Constable Lisa Large, who told him that no further action would be taken against him. She also stated that a pickaxe handle and a target list would not be returned to him. Privacy was a witness to the authentic proceedings. Later that day, a small group of ALF stalwarts celebrated his narrow escape from the clutches of the law. So this document seems to suggest that you had a target list that was seized. Do you recall that?
No, no, I don't recognise that description.
Did you have a list of individuals associated with the Leyden Street slaughterhouse in your possession at your cover address?
Well, unless they appeared in sort of the widely circulating documentation as part of the campaigning literature, no.
The conclusion, as it were, of this criminal investigation is that no further action was taken against you. Do you recall that?
Yes.
Did you have any understanding of whether that was agreed upon in advance, or whether that was a happy coincidence that conclusion was reached?
Well, my assumption was that was part of the plan.
You appear to have gone to this return on bail alongside or accompanied by an ALF activist. Do you recall that?
Yes.
And then later, after that had happened, later that day, it says a small group of ALF stalwarts celebrated your narrow escape from the clutches of the law. So would it be fair to say that the activists with whom you were associating took an interest in your arrest and interview on this occasion?
Yes. Yeah.
The second paragraph refers to a letter of solidarity from Jeff Shepherd and a series of supportive meetings with Brendan McNally as examples of net gains from this operation. Do you recall a letter of solidarity from Jeff Shepherd?
No, but we were in correspondence. I can't quite place that, but it would have been a natural thing for him to have done.
and then a series of supportive meetings with Brendan McNally. Does that ring any bells with you?
Well, there was there was the conversation with him that evening, the previous evening we spoke about.
And what about a series of supportive meetings following that?
I don't know about a series. No, I mean, it was obviously alluded to every now and again. But
can I ask you about the final paragraph? It's been gisted over the top of a redaction, but it refers to Bob Lambert discussing a plan to undermine George. And it says any progress is to be reported to him before any action is taken, and it will be discussed with HN1. Do you recall discussions with Bob Lambert about plans to undermine George?
no,
Was there a broader SDS strategy, as far as you were aware, of taking action to undermine targets of undercover deployments by SDS officers?
no,
Do you recall yourself being involved in any action to undermine George?
no, not at all.
In order to avert George's suspicions by this date, based on the documents we've just looked at, a decision was taken not to alert the police before you attended the home visit on the 20th of February. A plan was put in place to obtain warrants to search your cover address and vehicle and to arrest you in May. Did George's suspicions remain, notwithstanding all of those events?
I don't know.
You don't know if he remained suspicious of you after that?
No, I don't. I just, by that time we were sort of living with each other, as opposed to sort of knowing how to sort of coexist while remaining at a distance. So didn't come up in conversation with me directly, and I think there's that additional aspect which we've touched on before about others finding him quite tricky. So it was sort of almost in his behaviours, slightly undermining his credibility.
So can you assist us at all as to how it was that Bob Lambert appears to have come to be discussing ways potentially to undermine George?
Well, I don't know what that means. There were sort of frequent suggestions as to, how's this going to resolve itself, and each time was met with, from my perspective, no, that's not going to work. So it was, and I think, by and large, I think I was right. It was more sort of living with it and sitting it out, as it were.
All right. Can we move on, please, to look at documents which relate to you giving evidence as a defence witness on behalf of LTD? Please consult the cipher list if that doesn't mean anything to you as a cipher.
Thank you.
And if we start, please, by looking, just briefly touching on two intelligence reports that are attributable to you, MPS 0745833. It's a report of the 13th of May of 1994. It's your C242, so. At HM1, we see your unique identifier there on the cover page. And can we look, please, at the second page? A report about LTD dated the 13th of May 1994. And on the second page, we see reference to her appealing against her conviction under Section 5 of the Public Order Act at a magistrate's court in 1994, arising out of her arrest the previous year outside the Brighton Conference Centre during an anti-vivisection demonstration. So by May 1994, she is appealing a conviction that she's received. And then if we take that down, please, and have on the screen MPS 0245911, that's your C301, sir. This is the 6th of February of 1995. HM1, another report about LTD. And if we look at the body of the report, she's recorded now to be appealing against 2 recent convictions, first relating to an arrest in 1993 in Brighton, and the second during a home visit to a Cheshire huntsman. Can we take that down, please? That's just by way of background to refresh your memory, HM1, and have on the screen MPS 0526756. It's your B122, sir. And can we turn to page 3? And can we zoom in on the text, please? We have an SDS briefing note, HM1. It's got Bob Lambert's sign-off on it, concerning your attendance as a defence witness at court. The paragraph 1 provides some background about your deployment. Can we look, please, at paragraphs 2 and 3? It describes LTD as a long-standing and extremely well-placed ALF activist who has taken you into her confidence. Resident in privacy, she is a frequent visitor to London and one of a small group of activists who are trusted by ALF cells operating in different parts of the country. Having proved herself on active service, taking a leading role in an ALF incendiary device campaign against department stores in the 1980s, she now operates as a talent spotter and courier. On Privacy April 1994, you drove her to Brighton for an afternoon meeting with ALF contacts, aware that she would be attending the magistrate's court in the morning to answer a charge under Section 5 of the Public Order Act, threatening behaviour, arising from an incident at the animal rights demonstration in Brighton in July 1993. Excuse me. Fellow ALF activist Privacy, based in Privacy, was due to give evidence on her behalf. This information about you driving her to Brighton for the afternoon for a meeting and being aware that she was to attend court, that's information that must have come from you, isn't it, HM1?
Yes.
Can we look, please, at paragraph 4? In the event, Privacy was unable to attend court, and LTD asked Detective Sergeant HM1, who had been present on the same demonstration, if he would give evidence on her behalf instead. Naturally, he had little choice and agreed. In terms of what he had witnessed in his coverall at the demonstration on the day, he gave a brief and accurate account concerning what he had seen, without calling into question the integrity of the police evidence. That note gives the impression, doesn't it, HM1, that you were, in a sense, caught on the spot by this request, and so you were left with little choice but to agree to give evidence.
Well, I had a choice, and that was a choice I made, yeah.
But you were, on the way it's expressed here, you were put on the spot, weren't you?
That's as I recall it, yes. Yeah.
In fact, you had given a witness statement, you say in your statement to this inquiry, to LTD's lawyers in advance. Is that right?
I don't recall a chronology, but I'm not contesting that.
And you drove her to Brighton that day knowing that she had a court appearance in relation to that matter?
Yeah, I think it was in connection with that and meeting others referred to in the earlier note.
had you not anticipated at least a risk that you might be asked to give evidence as a defence witness on this day?
I can't recall degree of thought I gave to that.
Was it not the sort of thing that you would have been looking out for in advance so that you could discuss it with your managers?
Ideally, yes. Wasn't always possible to do that.
Can we have up on the screen your witness statement, the section where you deal with this, page 229, please? So, subparagraph, this is 502 D. Where you talk about being asked to fill in for the other individual who didn't turn up. You say, I found out that day and agreed to give evidence on her behalf because I had been present at the index events and she asked me as a favour to a friend. It would have been inconsistent with my cover persona to refuse, especially as I had already submitted a witness statement, brackets, after discussion with my managers, though I was not due to be called. So that rather gives the impression that you didn't think you would be called as a witness, but you had prior discussion regarding the provision of a witness statement in support of her defence.
Yes.
Do you recall discussing it with your managers now?
I can't, I recall discussing it at some stage. I can't remember the exact chronology.
Are you able to assist us with the nature of the discussion? What was under consideration?
Well, I can only surmise from what eventually happened was the thrust being that all I've contributed here is nothing that contests any of the evidence, but is an accurate reflection, description of what I witnessed that person doing at the time of arrest.
Any reflection that even the name on the statement had the capacity to mislead if it was submitted to the court?
Discuss. I mean, look, my view was that I wasn't misleading. It was accurately reporting and not contesting even any of the police evidence per se.
Your name was misleading, wasn't it, if submitted to the court?
Well, so that's only as much as the whole operation was misleading in that sense. It was such a benign contribution in saying that at no stage did I see that person engaged in that type of activity. It was right at the I guess, benign end, and was not in any way contesting or challenging any of the evidence behind the original charge.
Did you see no material difference between misleading your targets as to your true identity and misleading a court as to your true identity?
Well, this was a discussion with the office in which this was a collective. This is what happened. It was a benign end of the scale, doesn't contest, doesn't challenge, adds very little.
HM1, can I ask you to focus on my question, which is about giving a false identity to a court? Did that trouble you at all?
Not in the context of the operation, but for the name, everything else was accurate about what I was reporting in relation to the allegation and what I was being asked whether I'd seen.
And presumably your managers gave permission for you to submit a statement to LTD's lawyers, knowing that if submitted to the court or if you were called to give evidence, you would do so not in your real name.
Yes, I think because of this articulation of how benign it was and how it didn't challenge.
So the material factor was the nature of the evidence you were to give and not the name that you were to give?
Yeah, I think it was, as I recall, it was me saying I didn't see any of the activity being described leading up to the arrest, which is factually true. It wasn't saying it didn't happen.
If we go back to the briefing note that Bob Lambert put together, please, MPS 0526756, page 3. So that was at your B122. And it gives a summary of your evidence that was given to the court. On Friday afternoon, the 11th of June 1993, he was one of 30 or more demonstrators present during a 3-day demonstration outside the Brighton Conference Centre, where a group of vivisectors were holding an annual conference. It was a peaceful but passionate protest. When vivisectors entered or left the building, they were subjected to a hail of abuse from protesters. He saw vivisectors confronted. Can we go over the page, please? Confronted by female demonstrators who, inter alia, blew whistles close to their faces. Asked if he had seen the defendant, LTD, blow a whistle close to the face of an individual leaving the conference centre, he answered truthfully that he had not. Asked if he had seen the defendant cautioned for using insulting words by the arresting officer prior to the alleged incident, again he answered that he had not. Asked if he had seen the defendant throw away a whistle upon or immediately after arrest, he replied that he had not seen her dispose of such an item. Can we carry on, please? Questioned about his proximity to the defendant during the demonstration, he stated that, to the best of his recollection, he had been with her at the material times. 6. It will be readily appreciated that LTD's defence consisted of mistaken identity, that the police officer mistook her for a fellow demonstrator, who may well have been blowing a whistle close to the face of a vivisector. The purpose of your evidence, to the effect that you were with her at all material times and did not see her do the things that the police were alleging that she did, was inevitably to undermine the prosecution case, wasn't it?
So I don't remember being as categorical as linking my presence to her at all material times. These were sort of, moving feasts of people moving around, and quite volatile scenarios. So those, what I'm claiming not to have seen is absolutely accurate.
Yes, you didn't see the things that the police were saying she did.
Yeah, but I'm not saying that I could have missed, and therefore because I was with her at all times, which I couldn't have been at all times, there wasn't an occasion where she did it. So I wasn't contesting that.
Bob Lambert wasn't in court when you gave evidence, was he?
Well, I don't believe so.
And so the information included in this note about the evidence you gave can only have come from you, can't it?
Well, I didn't write that note. So as we've alluded to many times, other than written by me, which it wasn't, I would not have got to see that description.
Did you give a copy of the witness statement you had given to LTD's lawyers to your managers?
I don't believe I had the opportunity to do that. I don't recall doing that.
And so either Mr. Lambert has made up that you gave evidence that you were with her at the material times, or that must have come from you. Those are the two options, aren't they?
Well, all I know is that I could not be certain that I was with her at every moment of that demonstration to account for her conduct.
If that was the nature of your evidence, do you agree it wouldn't have been terribly helpful to LTD's defence?
All I can say is what I did say, and it was part of my articulation of it not being in any way to challenge or rather dispute head on, but was more an accurate articulation of what I witnessed. So yeah, not tremendously helpful, but helpful to a degree. That was the balance.
And so to that degree, you were giving evidence favourable to the defence and necessarily unfavourable to the prosecution and to the police case, weren't you?
Well, I mean, I didn't articulate it in that way. I was satisfied I was giving accurately what I saw and what I didn't see.
Did you consider at any stage that by presenting yourself as a fellow demonstrator rather than a police officer, that in itself misled the court?
No, I didn't. I mean, that was absolutely central to every day of my operation.
But with regard to the course of criminal justice,
Well,
was it not relevant for the magistrates to know that the person they were hearing from was a police officer and not simply a friend of and fellow demonstrator with the defendant in the case?
Well, that was for the wider office to manage. This wasn't, I didn't set a precedent in doing this.
The question isn't whether you set a precedent, HM1. The question is whether you considered and reflected on that aspect of misleading the court.
No, the only way of answering in the way I just did is I put my faith in the office that this would have been, this type of argument would have been had and adjudicated on to the satisfaction of the organisation.
Did you not at any time exercise any individual judgment in the course of this?
Well, for 95% of the time, that's exactly what I was doing.
In connection with giving evidence for LTD?
Yeah, it's how I got to this is right at the benign end of any sort of moral professional maze on this particular issue of misleading or not misleading. So yeah, that was a judgment that was owned by me, articulated by me, and conveyed to the office in that way.
But LTD, unbeknownst to her, had a police officer who could come to court to say that he didn't see her do the things that another police officer was saying she did. That wasn't allowing the course of justice to progress as it should, was it?
Well, I wasn't saying that she didn't do what it was claimed she did. I was claiming that I didn't see it happen, which was factually true.
And that is evidence of assistance to the defendant in the case, isn't it?
Well, it's accurately a sworn statement to the effect that that is absolutely true.
Are you reluctant to accept that you gave evidence in a case that was of assistance to the defence?
Well, it wasn't for me to make that to make that judgment. Yes, I was doing it. Please, will you do this? You were there. Can you write what you saw? Yes, I did that. It was accurate. It is what I saw, regardless of who that helped or not. What it didn't do was contest or make allegations that the evidence for the prosecution was in any way faulty.
So saying that you didn't see LTD do the things that the police said she did, in your view, didn't contest the evidence for the prosecution at all?
Well, it doesn't, because it's saying that implicitly it could have happened at moments when I didn't have full sight and visibility and hearing of the person concerned.
If we return to the note that Bob Lambert wrote, paragraph 7 asserts that your evidence was accepted without serious challenge and LTD was duly found guilty. If the evidence of a defence witness was accepted without challenge, well, let me ask in a different way. The two assertions that your evidence as a defence witness was accepted without serious challenge and LTD was duly found guilty, aren't those two things inconsistent?
I don't see how
Well, if a police officer gave evidence for the prosecution saying that he saw LTD doing the acts alleged, and you gave evidence saying you were with her at the material times and you didn't see her doing the acts alleged, and she was found guilty of doing the acts alleged, then how could your evidence have been accepted?
So I don't recall using the words "at the material time."
So you gave evidence that you weren't with her necessarily at all times, and you didn't see her doing the things alleged.
Yes, as I keep coming back to.
Paragraph 10, please, of this document. Mr. Lambert concluded that he was satisfied that you had behaved in a thoroughly professional manner throughout and maintained cover in the best traditions of the SDS. There's been an intimation that an appeal would be lodged, and his conclusion is that you might be called to give evidence on her behalf again, but in operational terms that would pose no problems for the SDS. Do you agree with the conclusion that you acted in a thoroughly professional manner throughout in regard to these criminal proceedings?
Yes.
And do you agree that if asked to give evidence again on appeal, it would pose no problems for the SDS?
Well, if that was, should that event have taken place, which I don't think it did, yes, it would have been an issue to work through. But I think that line is with reference to this will be addressed in due course.
Could we have a look, please, I think it's over the page on this document. Thank you. Paragraph 12 asserts that SDS policy and precedent is clear in respect to field officers attending court as defendants, but the same cannot be said in respect of attendance at court as defence witnesses. SDS policy guidelines regarding participation in crime address the subject, but clearly not in the context of this case, which consists of a minor public order offence. Can we scroll down to pages 6 and 7 of this document, which contain those SDS policy guidelines regarding participation in crime? Thank you. And could we look, please, at the bottom of the first page to start with, just for the context? So, where an SDS officer obtains information about the intention of others to commit a crime in which they intend he/she shall play a part, his/her participation will only be allowed to continue where, and then subparagraph E, which is the material part here, at no time will an SDS officer commit himself or herself to a course to mislead a court. This could include appearing on behalf of a defendant as a witness. Were you aware of those guidelines at the time?
Not specifically, no.
Do you consider that anything about that is unclear on the question of whether or not you were permitted to mislead a court?
Well, it's got plenty of ambiguity there as to, it's got the word could, and it leaves room for a case-by-case discussion of whether something's in breach of or falls within those guidelines.
I'm asking you about the first sentence. At no time will an SDS officer commit himself to a course to mislead a court. Is there anything ambiguous in your mind about that guideline?
No.
Did you not mislead the court, if for nothing else, as to your real name and the fact that you were a police officer?
No, I don't consider in the entirety of this event and what I was contributing to be a misleading.
Right, so turning up and saying, I'm Matt Rayner, a fellow demonstrator and animal rights activist, was not misleading the court?
Well, I wasn't misleading a court in terms of the accuracy of the evidence or contesting any of the police evidence.
So your view is that the course of conduct you engaged in was not contrary to this guideline?
On balance, absolutely, yes.
The guiding principle in regard to whether or not it was appropriate for you to give evidence on behalf of the defence in this case appears to have been, but correct me if I'm wrong, appears to have been the importance of you maintaining cover. Would that be fair?
Yes.
Rather than any concern about whether or not the criminal justice system was allowed to go or allowed to proceed as it should?
No, I think it always operated within that, within those parameters.
There is no, the inquiry has located no written report from you of the events of the day when you gave evidence at the magistrates' court. So when you drove LTD to Brighton, can you think of why you might not have submitted a report of the events of that day?
No, no explanation for that.
If we go back up, please, go over to page 11 of this same document that's on the screen. So still notes from Bob Lambert. Your B122, sir, still MPS 05267556. Thank you. We find a note from, it's October, I think 1995. Thank you. And it is still contemplated, based on paragraph 1 of this report, that you might give evidence in the Crown Court as a defence witness for LTD on her appeal. Do you remember that remaining a possibility?
Yes, it's coming back to me.
Paragraph 3 asserts that you had been suitably advised as to your course of conduct and reminded of the relevant guidelines. When you gave your witness statement to the inquiry, you said that you weren't reminded of the relevant guidelines. Is that right?
I don't remember being shown relevant guidelines, no.
Looking back, might it have assisted if you had been shown those guidelines, or do you think you would have taken the same course?
Yeah, for this particular scenario, I would have taken the same course. I'm fairly certain, because even looking at them now, I don't think it breaches those guidelines.
Could we take that down, please, and have up MPS 0245731? It's your C405, sir. Just to complete the picture, HM1, this is a report from, in fact, it's dated the 29th of November 1995 at the bottom. And the second paragraph, please. It's a report, a wider report, but it records that LTD had planned to travel to a meeting to coincide with her appeal, but that changed because in the absence of one of her witnesses' privacy, she negotiated a further adjournment. That suggests, doesn't it, that she had an alternative or additional witness available to her potentially?
Yes.
Do you recall that being the case?
Well, she talks about one of her witnesses, no idea how many.
Right, so do you recall being one of many defence witnesses?
No, I have no recollection of that at all, how many I was among.
If you had been, if there were other witnesses available to her, would that have affected your decision about whether or not to go ahead and give evidence on her behalf?
What, originally, or for the...
In either case.
Well, that isn't... Well, I don't know. I mean, that's not what transpired. She asked me specifically, knew I'd been there. And that was the beginning of the story, as it were.
I think your recollection, is it that you didn't end up giving evidence in the Crown Court?
Yeah, if I did, that's completely gone from my memory. I don't believe ever stepping foot inside a Crown Court.
And just for completeness, if we put on the screen, please, MPS 0732480, that's your B139, sir. And page 2, please. And particularly the paragraph closer to the top of the page. We see a minute from Detective Chief Inspector Edmondson, HM1, on the 21st of November, noting that LTD's appeal had been adjourned until January 1996. But no indication there of whether it was still expected that you would give evidence. May or may not assist you in your recollection as to whether you did, but for completeness, I've put that up to refresh your memory.
No, thank you. Just reading the whole thing. Did it go ahead on January 96? Do we know?
The inquiry hasn't found any records to assist either way, HM1.
Yeah. Gosh, I really don't believe that took place then, or that I couldn't have been involved in that.
Do you have any recollection of giving evidence in a Crown Court in your
No.
cover identity?
No, it's what I went a couple of sentences ago. I never stepped foot inside a Crown Court in this context.
All right, thank you. Can we take that down? You have also given evidence to the inquiry in your written statement, recalling that you gave evidence on behalf of Jeff Shepherd in respect of a similar offence, a Section 5 Public Order Act offence. Can we have on the screen, please, page 235 of your witness statement? In fact, can we start the page before, just to have the context? Thank you. Paragraph 512, by reference to notes of the Operation Hearn debrief with you, which record you saying that the only time you remembered appearing in court was as a witness for a case when Jeff Shepherd was arrested outside Harrods for a public order offence whilst wearing a mask. I appeared as a witness and told them that I had attended the protest with Shepherd for a peaceful protest. I would have answered the questions truthfully. This was a true account of the Shepherd trial and a true account of my memory at the time. As the inquiry has not located any written records relating to an incident matching this description, I will describe these events insofar as I am able to. Before I go to that detail, HM1, how confident are you in this recollection, even in the absence of any written record being found?
Yeah, I know there was confusion probably on my part as to whether it was Harrods or whether it was a fur shop. But in terms of the court incident, then yes, I do have recollection of this.
And can we look then, please, at what you say about it in the subparagraphs on that page that follows? Okay, so you recall it being before you gave evidence on behalf of LTD. You were shown some information that indicated he was arrested outside a fur shop in June 1993. And you say at subparagraph C, at the time of Jeff Shepherd's arrest, we were holding up anti-fur placards and giving out leaflets. I had not seen or heard a particular incident that led to the arrest, though I saw the arrest. He was arrested for a public order offence and charged. Can we go on, please? When the case went to court, I agreed to give evidence on Jeff's behalf because he asked me to. In my evidence, I said I had not witnessed the relevant conduct, but I admitted it was noisy. Thus, I was not lying, nor was I undermining police evidence. I've asked you lots of questions on this topic with LTD, but to cover it in this scenario, is your recollection when you were asked by Jeff Shepherd to give evidence on his behalf that you were already at court, or that you were asked in advance of the trial?
in advance.
And was it not possible for you to find a way out of having to give evidence in his defence?
Not credibly.
Because,
I was there with him.
but based on what you say in your statement, you had not witnessed the relevant conduct. So could you not have said to Mr. Shepherd, I'd love to help, but I didn't see what happened before your arrest?
Could have done. It would have been pretty weak.
Weaker than giving evidence, which was not terribly helpful to his defence?
Well, it was giving evidence based on what I saw. So, and I did say that in terms of it, what the general atmosphere was, it was noisy. We were holding up placards, which were sometimes quite provocative.
But that wouldn't have assisted Mr. Shepherd's defence, though, would it, that evidence?
No, but he asked me to, and I did, and that's what's happened. But in terms of getting out of it, it would have been pretty feeble, and I would have considered, had I asked, to be pretty inexplicable that if you were there, you wouldn't at least be prepared to turn up and give evidence of what you saw.
Even if you saw nothing of the relevant conduct?
Well, so there was general conduct, which he knew would not be necessarily helpful. So noisy, provocative photos to passers-by. No one denied that. I didn't deny that. Sorry, go on.
What was it you could say that could assist Mr. Shepherd's defence on this occasion?
That in terms of I think there was reference to, I really can't remember, but in specifically the incident that led up to his arrest, I wasn't aware of. I wasn't aware of what was different in that particular moment than had been sort of more or less the case for the whole of the protest.
Does that mean you gave evidence that you didn't witness any conduct justifying his arrest?
No, because I'd gone as far as saying, look, at any stage, this is borderline threatening behaviour for all of us when you're sort of fairly noisy in this sort of, if you like, very respectable part of London to unsuspecting passers-by with posters of provocative pictures linked to the fur trade. It is quite a threatening environment. So that was there from, that was there from the off.
But in terms of Mr. Shepherd's conduct, are you saying your evidence was that you didn't see him doing anything differently from anyone else?
Not at the moment of arrest, no.
That would have undermined the prosecution case, wouldn't it?
Well, all I agreed to do was talk about what I saw.
Subparagraph E says that you cannot recall the detail of conversations with managers before and after this case, but the emphasis was on not misleading the court. Do we take it from that you recall that there were conversations with managers, just not the detail of them?
Yes.
And in terms of all of the things I've asked you about in relation to giving evidence from LTD, the fact that it wasn't your true identity, the fact that you wouldn't disclose you were a police officer, were those all things considered similarly in this case, as you've explained they were considered
yes,
in the
absolutely.
LTD case?
Yeah, this was not taken lightly. This was not a casual event. I mean, never mind just for the reasons we're talking about. The actual it's actually quite intimidating turning up in that scenario against the background of everything we're discussing here.
And so that was the subject of discussions with your managers?
Yes.
And what about the topic in terms of misleading the court? Do you remember what was discussed in connection with that?
Well, I absolutely considered I'd done enough in explaining the scenario and this thread of I would not be shying away from the noise and slightly threatening in the eyes of others nature of what was on show. And I also wouldn't be contesting directly whatever the evidence was against him that led to his arrest.
But saying that you didn't see the conduct that he was charged with does have
No,
that effect, doesn't it?
yeah, no, but I mean that could have. It was borderline from, it's borderline from the moment we got there, really. And so, one bit of confrontation, one bit of angry language, one gesture. I mean, I didn't spot the actual catalyst that led to his arrest for, look, let's face it, was a fairly minor, at the softer end of a breach of public order.
What's the relevance of it being a minor offence in your consideration of this?
Well, it is surely part of the story, is one, if you put the whole scenario together, this was not a big event in terms of anything that I was like to have a material contribution to other than supporting and report and giving evidence accurately as to what happened with regards to a charge of, I think it was threatening behaviour. I believe it might have been the wider public order offence. It was the whole sort of, the whole way of life in this is grey, I accept. But wherever you get to in this articulation of judgments to be called, this was at the softer, benign end of the grey area.
Can I ask it this way, so you have the opportunity to comment? Was it the case that a balancing exercise was being done and it was considered less serious to mislead the court as to your identity and the fact you were a police officer if the charge was less serious than it would be if the charge was more serious?
No, I don't think it was that. It was that binary. I think the key point was misleading the court in terms of the fabrication of one's own evidence was not the issue here, because that isn't what was happening. It was accurately and under oath describing and not even shying away from the sort of slightly threatening environment that was presented. All it was saying was didn't see and couldn't help with, when questioned about it, what the catalyst for actually led to his arrest. I mean, to be honest, I don't think I was even very helpful to Mr. Shepherd, and even going as far as talking about the noise and the sort of threatening, sort of the slightly shocking photos that were on display to people in this part of London.
Right, thank you, HM1. I wonder if that's an appropriate time for a lunch break.
Certainly. We'll now break for lunch. It's slightly after 1 o'clock now. Can we resume at 2 minutes past 2?